Welcome to this Public Interest Before Corporate Interests YouTube presentation. My name's Joseph Toscano. This week we'll be looking at a bit of a different subject, the role of the Australian Constitution during the COVID-19 crisis. That's why we've got the green and gold, the Australian national colours. So if we're going to talk about the Australian Constitution, we may be in a Australian setting. It's quite interesting that Australia chose the wattle and green and gold as its national colours when most of the land is semi-arid or arid, but that's another story. Now, I think before we delve into the role the Australian Constitution plays during the COVID-19 crisis, we need to have a little bit of understanding about the Australian Constitution, because I think it's one of the constitutions that in the world that very few people know about, including most Australians. You'd be surprised how few Australians actually know we have a constitution, and a constitution is a very simple concept. It's the framework which determines the legislation which can be passed by Parliament at the federal level. That's what the Australian Constitution is. It is the building blocks of the legislative agenda of this country since Federation since 1901. And we need to understand how it came about. Because at the end of the 19th century, in the 1890s, there were two significant constitutional conventions which were held in Australia, which looked at the possibility of Australian independence. And the major dilemma which faced the constitutional fathers, because there were no constitutional mothers, but the major thing which faced them was the concept of federation, because Australia consisted of 6 independent British colonies: West Australia, Queensland, South Australia, New South Wales, Victoria and Tasmania. Obviously the first independent colony, or the first British colony, was New South Wales, which initially incorporated Victoria. The second was Tasmania, and then obviously Queensland, South Australia, Victoria and Western Australia each achieved their own independence. But that was the dilemma which faced Australians at the end of the 19th century. If there was going to be a country called Australia, would it be a unified country, or would the Australian continent be made up of 6 independent colonies, or 6 independent nation states, sovereign nation states? These colonies will be transferred into independent nation states. So this was the major issue which played on the minds of those that are involved in the constitutional conventions: how to get the 6 disparate groups of people to federate into one country. And a number of referendums were held before federation was achieved. And the interesting thing is that although Tasmania, Queensland, Victoria, South Australia and Western Australia were interested in federation and voted for federation, 2 referendums were held in New South Wales before the people of New South Wales wanted to become part of this new federated sovereign nation state. And even in the second referendum, they're only able to achieve 54% of the vote. And the main reason people in New South Wales didn't want to federate was the fact they didn't want to support economically and the rest of the country. So in order to sweeten the constitution to suit the smaller states, the parliamentary system was divided into 2 houses: a lower house, which was the Legislative Assembly, which was based on the number of people in each electorate, And then in order to satisfy the smaller states like Tasmania, with an exceptionally small population at that stage of less than 200,000, and today it's only 500,000, they had 12 senators appointed or elected for each state. And the Senate was the House of Review, and the Senate could temporarily block legislation, as we see constantly. So we are in a federation. It's a federation. And over the last 120 years, what has happened is that the states have given over more and more of their power to the central government, or the federal government. So what has COVID-19 highlighted? COVID-19 has highlighted some exceptionally important issues which most people are not aware of. The first thing, which I've spoken about ad nauseum over the past years, is the fact that the Australian Constitution has no human right provisions within it. It was never designed to incorporate protection for the individual from the arbitrary exercise of state power, except in the case of religious freedom, and except in the case of compensation if the state or the federal government compulsorily acquires your land. They are the only two pieces of legislation, two sections in the Australian Constitution which protect the individual from the arbitrary exercise of state power. Concepts like freedom of speech, freedom of assembly, freedom of association are not incorporated in the Australian Constitution, and they were not incorporated in the Australian Constitution in the first place because those that were involved in drawing up the Constitution and presenting the referendums in the various states were more interested. They're actually much more interested in the country federating than the concept of human rights. So the first thing you will understand is there is no such concept in the Australian Constitution as a sovereign citizen. In a sovereign nation state, power lies in the hands of the state. The Constitution makes that very clear. The state has a monopoly on the use of force. That's what gives it the authority to impose its will, sometimes willingly and sometimes unwillingly, on the population. And the payback is security for individuals living in the country. That is the payback, that people give up those rights and liberties. So COVID-19 has highlighted a number of exceptionally important issues. One, that we are still a federation, and state premiers have extraordinary powers. They have powers to declare states of emergency. They have power, as we've seen in Victoria, to declare a state of disaster, which gives the Premier almost total control about what is happening in the state of Victoria currently during the stage 4 lockdown. The state of disaster even gives the Premier the power to ignore legislation which has been passed by both the federal and state government. We've seen the closure of borders. And what brought people into the Federation in the first place was the concept of free trade, the concept of movement through borders. But we have now seen the closure of borders by state premiers, and sometimes on the most whimsical of conditions. We've seen the ridiculous situations of people from Canberra being refused the right to exit Victoria and go back to Canberra, as if a few hundred people sitting in cars are going to spread COVID-19 in New South Wales. So the issue is the extraordinary powers that state premiers continue to hold in this country in a federation. The other power that has been interesting is the role of the Australian Defence Forces. The Australian federal government has minimal power in terms of deploying Australian federal troops to assist state governments in dealing with disasters, whether it's a natural disaster, a flood or a bushfire or a cyclone or a tornado, or in dealing with a pandemic. The federal government can only enter a state constitutionally at the request of the Premier or the request of that state government for federal troops to be deployed. And we saw the ridiculous situation in Victoria where the Victorian state government hesitated in the early stages of the COVID-19 crisis in utilising the resources which the Defence Forces were able to provide in order to contain the spread of the pandemic. So once again, we have seen that this constitution has many limitations, huge limitations, when the central authority, an authority which has the right to tax individuals, has the right to tax individuals' income, which has the most resources, cannot provide those resources in a time of an emergency without the state's acquiescence is quite is an issue. So there are many issues as far as the Australian Constitution is concerned. The Australian Constitution was essentially a document which regulated trade between the states. And although you and I may have constitutional wet dreams, we can do nothing about it. But people like Clive Palmer, who seems to have constitutional wet dreams on a regular basis, has the resources in order to challenge the closure of state borders by state premiers, because it's quite... So, those of you who think the Australian Constitution provides protection from the individual, from the arbitrary exercise of state power, think again. As far as the Australian Constitution is concerned, even the right to free speech was an implied right, which was found by the High Court. Now, the High Court consists of 7 judges who are appointed by the Prime Minister or the Attorney General, the Federal Prime Minister or Attorney General. They usually the appointees reflect the political opinions of the government of the day. High Court judges are forced to resign at the age of 70. But we have seen recently, over the last decade, judges in their late 30s and early 40s appointed to the High Court, which means if they've got a conservative agenda, they will be able to continue, the governments will be able to continue that, a conservative agenda in terms of the interpretation of the Australian Constitution in the High Court for 30 to 40 years. Now, this is very important because over the next few months, 2 High Court judges will be retiring. This gives the Morrison government the ability to appoint conservative, reactionary High Court judges who will have a major impact on the interpretation of the Australian Constitution over the next 30 to 40 years. For example, now Clive Palmer is involved in an action against a constitutional action in the court regarding the rights of the state to close their borders, because he was prevented from entering Western Australia to see some of his mining assets, and he believed that this was constitutionally incorrect. Now, you and I can talk about it. He has the resources to take that case to the High Court. And interestingly, initially, the Morrison federal government supported Clive Palmer's attempts to remove the ability of state premiers to close their borders because it inhibited free trade. So these are things that we need to keep in our minds. The Australian Constitution does not protect you. It does not give you the right of association. It does not give you the right of free speech. It does not give you the right of assembly. These are all common law rights which can be removed by governments at any time. And over the last 20 to 30 years, we have seen a raft of legislation, over 75 pieces of legislation, which have removed those common law rights. Secondly, the Australian Constitution is essentially a document which regulates the trading relationships between the states. Thirdly, the state premiers continue to have extraordinary powers in terms of being able to suspend any constitutional rights we have if they believe we are facing an emergency or a disaster. Or, in the federal sphere, interestingly, the Attorney General now has the power to ban any organisation he or she feels may pose a threat to Australian society. Not a security threat, but an economic threat. So, number of things we need to remember is, one, there is no such thing as a sovereign citizen in a sovereign national state. The state has a monopoly on the use of force. It has a monopoly on passing legislation. If there are no constitutional protections, the state can pass any legislation it likes at any time to remove any common law rights which you think you may be able, you think you can exercise. And we've seen this over and over again in this country. Also, the state has the power to detain people indefinitely, as we saw with asylum seekers. And you can be detained overseas, as we see with asylum seekers. And Australian citizens who think they are beyond that legislation need to think again, because our constitutional protections do not exist. And they don't exist historically, because when the Constitution was formulated at the end of the 19th century, it was formulated on the basis of attempting to federate 6 colonies into one nation state. So ultimately, what role does the Australian Constitution play in the COVID-19 crisis? Nothing. No protection for the individual from the arbitrary exercise of state power. No protection for the individual from economic disaster. No protection for the individual in terms of the freedom of movement, freedom of association, freedom of mobility. No protection whatsoever. If you're interested in pursuing these issues, I recommend highly that you have a look at the Australian Constitution. It's a fascinating document. It is one of the few constitutions in the world which is racially biased. The Australian Constitution gives the Federal Parliament the power to pass legislation for specific races. And the whole concept of the 1967 referendum, which recognised Aboriginal and Torres Strait Islanders as citizens in this country, a country that they had lived on for over 60,000 years, for over 2,000 generations, was the fact that the government had that constitutional power to pass specific legislation regarding race. And we've seen this used in a positive way to assist Aboriginal and Torres Strait Islanders in some situations, and we've seen it used in a negative way in order to introduce the White Australia policy, in order to deport Kanaks who had been blackbirded and brought to this country as virtual slaves back to their countries. And we can see it over and over again when the Howard government suspended the Racial Discrimination Act in order to forcefully use the armed forces to enter Aboriginal and Torres Strait Islanders communities in this country. So those of you who believe the Australian Constitution offers you any protection, it offers you less protection than the fig leaf that you see on Middle Ages statues.